Hi everyone, welcome back to Law with Dunk the Law Guy, and I'm producing today's second recording, which would therefore be the day 50 recording of the Case a Day series journey to make up for what I wasn't able to do in the week, covering cases across criminal law, tort law, contract law, and the English legal system. If you ever have a case you want me to cover, feel free to pop it in the comments section and I'll get round to it if I can. Today I'd like to close up covering cases relevant to the various strands of the coincidence rule by covering the case of R.V. Church 1966 and touching upon its relevance to transaction theory. Just so you're aware, there's a lot of content on a law A-level, so I really only stress Fagan v. Metropolitan Police Commissioner 1969 for continuing act theory and R.V. Faber-Melly 1954 for transaction theory. However, just in case you want to cover R.V. Church 1966, this recording is for you. In this case, the defendant knocked a lady out after having an argument with her in the back of his van. I think they were hooking up, not that I was there watching, but just from what I've managed to read online, he may have been struggling or been unable to satisfy her sexually, and she may have mocked him and may have even slapped him in the face. Be aware these details vary slightly across multiple law sites. The defendant thought she was dead after he'd knocked her unconscious, and so he picked up her body and dumped her into a river where she went on to drown. The defendant was convicted by the jury at trial with manslaughter, specifically unlawful act manslaughter, also known as constructive manslaughter, i.e. his battery caused her death. The trial judge gave direction to the jury that they could convict the defendant if they viewed his behaviour as a series of acts, which can be seen here. Specifically, Act 1 would be knocking out the lady, Act 2 would be dumping her into the river, Act 3 would be the victim drowning. The mens rea of the battery would be present when punching the lady, and so the mens rea of battery would be present within the transaction, grouping them together, when the series of acts are grouped together as one transaction. Also, the Court of Appeal went on to uphold the defendant's trial conviction. Additionally, please also be aware that R.V. Church 1966 is a key case to the crime of unlawful act manslaughter, specifically step 2 or the second part of the actus reus of the offence, which requires the unlawful act to be dangerous by way of an objective test. The Court of Appeal established the dangerousness test for unlawful act manslaughter to be proven, and the original wording from the case is a bit lengthy, so I've simplified it to simply ask, would the reasonable sober person foresee the risk of some harm from the defendant's actions? There is no need for the reasonable sober person to foresee serious harm, just some harm. Here you can see, I've not written this up, but here you can see, punching someone, the reasonable sober person would foresee the risk of some harm, and that's why step 2, the dangerousness test, would be proven in the case of R.V. Church. So not only does R.V. Church promote the dangerousness test, but also the dangerousness test is satisfied in R.V. Church. Anyway, going back to what I've written up, seeing as this is an objective test, it's irrelevant whether the defendant foresaw a risk of harm when throwing the victim into the river, because it's not a subjective test, it's an objective test. We only look through the eyes of the reasonable sober person for step 2 of an unlawful act manslaughter offence. Just so you're aware, whenever I'm teaching my students, I'm always saying, whose eyes do we look through? And that's a good hint for it's an objective test. We look through the eyes of the reasonable person, or a variation of whoever the reasonable person is. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you Tuesday.